They say that money is the root of all evil. It has become the source of many arguments, conflicts, and controversies for both private and public citizens. Money can also cause families to fight against each other. This usually happens when a person dies and family members fight over their inheritance. Under Philippine law, the legitimate spouse and children have rights to claim inheritance. What is the meaning of inheritance? Who has rights to inherit? And what is the process for claiming inheritance? These are some of the issues we will tackle tonight. Good evening, I am Attorney Karen Jimeno and you are watching Legal Help Desk on the Solar News Channel. This show is about making the law work for you by giving legal advice on topics that matter to you.
And I'm Attorney Rod Nepomuceno. Tonight we'll be discussing your rights on the issue of inheritance, what you need to know about claiming the assets or properties of a relative or loved one, and if you have the legal rights of doing so. Good evening, Karen.
Good evening. So our topic for today,
Yes.
very controversial.
Controversial and very interesting. My
Yes.
favorite subject matter in law school. in fact.
Really?
Yeah, it's my favorite.
Well, I'm saying controversial because I've heard of so many cases, even those that my mom have handled, na
Right,
some of the litigants, they say, kahit maubos na yung pera nila sa lawyers' fees, basta makuha lang nila, manalo lang sila sa kaso. So
Yeah.
I've noticed basta mana yung pinag-uusapan.
Yeah, and it's sensitive.
It becomes
because-
very emotional,
Emotional because the topic is about what I get and what you get.
And
all that.
sometimes
it's-
pride gets involved, no?
Yeah. No, and it's sensitive because of the sensitivity of the relationship. Diba?
Yeah.
It normally involves parents and children
Yes.
and spouses and all that. So,
But people ask me normally,
Yeah.
ano ba yung inheritance talaga?
Yes,
But simply put, it's just basically what you're entitled to. What you're entitled to inherit when someone passes away.
Right.
And I think, Rod, what we have to explain here would be yung difference between intestate succession and testate succession.
Right.
A lot of people don't even know may pinagkaiba ito, di ba?
Yeah.
I'll start with
Sure.
intestate succession.
Okay.
Simply put, ito yung pagka may namatay na walang iniwan na will. Yung walang sinulat na will, meaning basta na lang siya namatay and then he didn't plan for paano to distribute the properties.
And most people die like that.
Yes.
Yeah, most people die like that, yeah.
And what makes this different is that under the law, if you die without a will, your property is apportioned to certain people. Now, by operation of law, ibig sabihin according to the law na if you have a wife, for instance, and a legitimate child,
Right.
how do they divide that?
How do they divide it? Yun nga,
It's one half, right?
Yep.
Of the total assets.
Yeah, but maraming permutations yan because sometimes you have one spouse, sometimes two, sometimes, and you have a lot of legitimate children and a couple of illegitimate children here and there. So that's why it becomes a little bit muddled, no? But as Karen said, the law, our Philippine law provides for kind of a compulsory or mandatory division of your property.
Pagka wala kang will, it's the law that tells you kung kanino mapupunta yung mga ari-arian mo. And testate succession naman is if you wrote a will, meaning sinabi mo doon kung sino yung papamanahan mo. But one thing I'd like to point out is in other countries, you can actually decide na hindi ka magpamana dun sa sarili mong anak.
Yes.
So, may
jurisdictions.
mga kaibigan ako minsan pagka inis na inis sila sa isa nilang kapatid, parang sinasabi nila minsan, dapat, dad, huwag yun ang pamanahan yan. So, hindi pwede, di ba? That's something you have to explain.
Yeah, we have certain rules on disinheritance. No? It's not very simple to disinherit a compulsory heir. But what's important to note that in Philippine law, the law assumes that you love a certain set of people, and that's your legitimate children, and your illegitimate children, and your spouse.
Yeah.
And that's what the law kind of provides. Yun ang what the law provides as mandatory heirs.
Yeah,
no,
and
sa
something I think we
succession.
need to clarify, even if you write a will, ibig sabihin sumulat kayo ng kanino nyo ipapamana yung mga ari-arian ninyo, that doesn't mean na lahat ng pag-aari nyo will go to these people. Under our law, there's really yung tinatawag nila na legitim, meaning they will take a portion of your property and give it to certain people. So, twice pa makakuha. Kunwari lang, you have a wife, your legitimate wife. Kung tagapagmana yan sa property ninyo, sa will ninyo, hiwalay pa yan dun sa makukuha nila automatically. So, as
Oo.
soon as you die, meron tayong tinatawag na free portion that you can give away. Tapos, yan yung share ng wife as against yung mga legitimate children. And then, based on your will naman, kung ano yung makukuha nila sa will nyo.
And I think what's also important to point out is that there's always this error. No? Inheritance, ladies and gentlemen, refers to the properties, rights, and obligations of the person who's about to die, or the person in question, the decedent. It's always important to point out that the inheritance is the sum of all of that. That's, plus and minus all the properties and the rights and
In
obligations.
short, kung may utang pa yung pinagmanahan ninyo, kailangan mo nang bayaran yung utang. So, kung negative yan, then you won't get anything.
Yan. Okay,
Now,
so,
let us answer a few questions sent by our viewers. We have a question from our Facebook page from Dana. My parents were married in 1975 but got separated in 1990. They never got their marriage annulled. My father remarried and had 2 children with his second wife. Since my parents never got an annulment, does this mean that his properties will be inherited by us, his first family, including my mother? Or does the second wife and their children also have a share? So,
okay. In this case, in this case, obviously there was a second invalid marriage.
It was na hindi annulled. So it's a bigamous marriage.
It's a bigamous marriage. So therefore, you can't call the second wife as a real wife in terms of succession. No?
So sino lang magmamana dito? First, the legitimate wife. Next, of course, legitimate children. And it's the person asking this question. Kasama yung mga kapatid mo. And then, unfortunately, pati yung mga illegitimate children. You have to divide your father's property between your mother, yung legitimate wife, and then sa mga kapatid mo as the legitimate children, and all of your illegitimate siblings as well. But they only get half of the share of each legitimate child. So kalahati lang ng mga share nyo. Kunwari, kayo ang nakuha nyo after computing everything, 50,000 pesos. Lahat ng illegitimate child, 25,000 pesos lang ang makukuha.
So the rule is 1/2. No? The illegitimate children get half of what a legitimate child gets.
Let's take a short break. Legal Help Desk will return after these reminders.
Many Filipinos do not practice writing their wills. They have misconceptions that wills are only reserved for the rich. Most believe that any assets obtained by the parents will automatically be passed on to the children, divided equally among them. This is not the case for a lot of families. It's best to consult with a lawyer in formalizing your will. Wills prevent conflicts and controversies among family members. There are 2 kinds of wills: ordinary or attested will, and holographic will. Attested wills must be written and executed by a lawyer in a language or dialect known to the testator and must be subscribed by him at the end. Holographic wills, on the other hand, must be entirely written, dated, and signed by the testator himself. It need not be witnessed and can be made in or out of the country.
She is an only child. Her parents have already passed away and she claims to be the only heir of her grandparents. But her uncles and aunts refuse to return one of the properties owned by her grandparents. Minention mo sa akin na in-adopt yung father mo. He was adopted by your grandparents. So, why did they have to adopt your father?
My father is originally son of my grandmother. And then, ang stepdad niya, yung grandfather ko.
Stepdad. So, originally, illegitimate child yung father mo doon sa grandparent mo na, sa iyong lolo.
Lolo,
Tapos, in-adopt niya na lang. Okay, so yung lupa, andyan pa rin ngayon, pero nakapangalan pa rin sa iyong lola. Pagkatapos mamatay nung iyong lolo, nagkaroon ba ng parang settlement, yung tinatawag nating settlement of estate?
Wala eh.
Nung pagkamatay ng tatay mo?
Wala pa rin. Ngayon, kaya yun yung gusto kong mangyari sana. Kasi yun yung, hindi naman hinahabol. Because alam ko, akin yung lot na yon, yung property.
And we are back. You're still watching Legal Help Desk on the Solar News Channel. We are now joined by our guest for tonight, Attorney Jonathan Sarte. He is a partner at the Malcolm Law Offices and teaches civil law at the Far Eastern University Institute of Law. Good evening, Attorney Sarte.
Good evening, Karen. Good evening, Rod.
Good evening, Attorney John.
So we'll go to the case of May. As you can see,
Okay.
the controversial property here is a land that she claims to have inherited from her grandparents. So can you help us figure out, first, if she can claim this land? Second, how she can at least get it from her relatives who are now occupying it?
Okay, based on the facts that were shown on the screen, we prepared a diagram. From what I see, the property that came from Perla's husband,
Oh, si
Arturo.
Arturo.
Yes,
Arturo.
Yes.
she inherited that from Arturo, and that property, when Perla died, that property went to her son Romy, who is the father
father.
of May. Because from what I understand, Romy was legally adopted by Perla and Arturo,
Yeah.
and that gives him the rights of a legitimate child.
Yeah.
Perla died first,
Yes.
which makes Romy now the sole heir,
Yeah.
Okay, so
sole
you
heir,
mean-
sole owner of
Yes.
that property.
the sole owner of the property.
Yes. Okay.
And then Romy died in 2009. That same property now goes to May, who is
Okay.
the only daughter.
Yes.
Okay. Now, the question is, do the brother and sister of Perla, do they have the same rights to the land? I would say they don't, because at the time that Perla died, Romy, she had a son, Romy, who excluded the collateral relatives.
Right.
Wait,
Parang compulsory
pag
heirs,
namatay.
which in this case, a descendant. Yun ang tinatawag ng compulsory heirs.
Yes.
Automatically excludes
He
other
he
relatives.
excluded, yeah.
Other relatives like brothers and sisters,
Oo.
right? Kasi
Because
Nung
the
namatay.
brother and the sister are collateral relatives.
Right.
And then, attorney, there's another concern here. The fact that May is an illegitimate child, kasi hindi raw married yung mother niya and Romy, the father, would that still allow the brothers and sisters of the grandmother to claim the
Well-
property?
Well, no, because even if she is an illegitimate child, then she still will succeed to Romy's estate. The only difference of an illegitimate child is in the presence of a legitimate child, he will get only one half, or she will get only one
he or
half.
she will get
One
less.
half nung share
Of the
ng
share of the
legitimate
legitimate child,
right?
yeah, yeah.
And then her other question was, it's the relatives who built the house on this land, and they've been living in that house. So, is that enough reason, or at least legal basis for them to say na kanila na yung lupang yon?
No, that's not. If that is the case, then we will apply the rules on builder in good faith or bad faith. We
Yes.
have to see if the act
They
of
built it.
building was in good faith or in bad faith.
That's right.
Yes.
Since they were not really the owners, then probably they can be considered builders in bad faith.
May, I hope that answers your question. First of all, you have a right to own this land as the only surviving heir of your dad. And then also, you can claim that property from your relatives.
All right, May, I hope that helps guides you along. No? So we have a few more questions from our viewers. Let's try to answer them with the help of Attorney Sarte, of course. From our Facebook page, this question was asked by Lorraine. Now, during my single years, I've acquired a few real estate properties such as condominiums in various cities in the metro. I'm now married to my husband for 5 years. Can these be considered as conjugal properties or not? If somehow I died, yeah, will these automatically go to him? So that's a question.
Thinking ahead, if I
Oh, nga,
die.
if I die, if somehow I die. All right. What are your thoughts on that? I think the rules on marriage.
We apply the rule on what property regime
property
will
regime.
govern the spouses.
Yeah.
Now, first, of course, under the law, the first choice of a property regime would be in a prenuptial agreement. But if there is none, well, there's nothing in the facts. Then we go to the family code. I see that she was married in 5 years
Past
ago,
5 years. So
which
mga
is
2007 lang, yeah.
Then that would be under the family code.
Yes.
And the property regime would be what is called an absolute community.
Yes. Meaning that
Meaning, in which is everything that she owned while she was single will have to be brought
All
into
brought in.
the community.
Yes.
Including
Yes.
properties that she inherited, but in this
Yes.
case, kasi it was property that
Yes.
she purchased, so
Yes.
all the more this would be included in the pot.
Yeah.
no, in
So
the
Lorraine,
absolute
all
community
of
pot.
those condominium units that you bought before, those are now property of you and your husband.
Yes. Yeah.
Because this is considered absolute community.
Yes, I just wanted to correct because the question mentioned conjugal properties, and it's not the correct term. It should be
Yeah,
absolute,
absolute
community.
community.
The
Yeah.
good news for Lorraine is that all the properties of your husband also you
Yeah.
own 50% of
So
that.
I'm hoping that he
Yeah.
also owns a lot of property. Para hati kayo naman dun
Yes.
sa properties ninyong dalawa. But
Yeah, so it's
so
fair.
her question is, pag mamatay naman siya, then where will these properties
Well,
go?
in that case, then the husband is considered an heir.
Yes.
The husband will, well, first of all, the absolute community will have to be divided in two between the husband and the wife. So when the wife goes, the husband will get one half.
Yes. And if they have
And then
kids,
he is also an heir. Well,
Yes.
if they have kids, then the children, if they are legitimate, will share
will
the,
share.
the other half
According
Yeah.
to
with the husband.
the legitimate rules, no? Whether,
Yes,
and
yes.
also based on whether he had a will or she had a will or not.
Yes.
our next question comes from our Twitter page. Marie asks, my husband has an illegitimate child with another woman when he was stationed abroad. Does this child have any rights to his assets? The child is not a Filipino citizen. So,
We have
nagkaanak
here,
abroad.
we have here a situation where we have to apply the conflict of laws. The father is Filipino, the son is not a Filipino, but under the law, under Philippine law, the nationality law of the person whose estate is being considered.
Meaning yung
That
namatay.
is
Yeah.
yes,
Yeah.
yung decedent.
Oo.
Yung-
Yeah.
That is what will govern the
what-
situation.
And in that
So in
case,
this case, yung
Under
Filipino
Philippine law,
Yeah.
illegitimate children have a right to inherit. To
whether
the
or not they're
estate.
abroad or not, diba?
Yes,
they have the
yes.
rights
Yeah.
to inherit.
But the share of illegitimate children is half, di ba? Kalahati nung share nung legitimate children.
yes. If there are legitimate
Yeah.
children, then whatever is the share of each legitimate child,
Yes.
one half of that will be received by the illegitimate
Yes.
child.
All right.
So Marie, I hope that answers your question. This child will have a right to inherit from your husband, pero kalahati niyan, if you have legitimate children, it will only be half of what your legitimate children will get.
Okay. We have somebody on the line. Her name is Carmi. Carmi, what would you like to ask us?
Hi, good evening.
Good evening.
My grandparents had 11 children, but when they passed away, we found out that their ancestral land has no land title from the Land Registration Authority. So one of their kids wanted to acquire the whole property because she's single and she lives with my grandparents when they were alive. So he's willing to pay all the expenses, but it should be named after her. So my question is, do all the children of my grandparents have the right to this land, or can it just be named after one child? And also, is there a possibility that the government will retrieve the land?
All right. So in this case, there's a question of ownership of land. Is that correct?
Yeah.
Yeah.
But it's not clear kasi here, Marie, if the, Carmi, if the land is titled or
Titled,
not
yeah.
titled.
Well, first of all, the certificate of title is just a piece of paper that evidences ownership. Now, since she said that it's an ancestral land, we
Na
can
walang
assume
title.
na walang title.
Yes.
We can assume that the grandparents have been there since time immemorial. In which case, their possession, their continued possession, from the grandparents to the children, can be summed up,
Just presumption.
packed together, and it can ripen into ownership.
Yeah.
Yeah,
by,
that's what we
30
call.
years or more.
Yeah, that's what we call under the law as prescription.
Prescription.
But we have to clarify here, Carmi, that there are some types of land na hindi mo pwedeng ma-acquire by prescription. Meaning, regardless of how long your grandparents stayed at that land, kahit 50 years pa yan, it can never ripen into ownership. So here, you have to check with the Register of Lands. Is this, does someone own this land previously? Pagka meron na may-ari dati pa, kahit na matagal na dyan yung grandparents mo, you don't own this land. But assuming it's ripened into
Yeah.
ownership.
Well, assuming, if we assume that the grandparents were the owners, then that would mean all the children, at the death of the grandparents, all the children would be co-owners of that land.
Yeah.
And not
Yes.
only one,
Not only one.
daughter.
Yeah.
Yeah.
In
Because
which
she's
case,
saying,
there could be a possible case of representation here because
Yes.
they're talking about an aunt. No? So the assumption is maybe these grandchildren,
Yeah.
they had parents
Yeah.
who are no longer there, and they in a way replaced
Yeah,
their
they-
parents. No? So they're questioning their aunt. No? So
Yeah.
so assuming there is title, the aunt basically the aunt and the grandchildren have rights.
Yes, yes. Well, the argument of the aunt that she was the one who took care of the grandparent is really doesn't really vest in her sole
Right.
ownership
Or if
of the
she's
land.
the only one who wants to pay for yung mga real property taxes
Well,
na
not-
hindi nabayaran.
Not even, because we have to go back to who was in possession. It was the grandparents who were first in possession, and if we go by the prescription, like you said, then the owners would be the grandparents.
Right.
Although,
That's right.
Carmi, you and your other co-heirs, kung sino man nag-claim din ng property, you have to pay. You have to reimburse the aunt for the
Yes.
real property taxes or expenses that she paid for that property.
Right. So, Attorney Jonathan, she has one final question, yung about the possibility of the government retrieving the land, no, which is not titled. What's your take on that?
Well, of course, for non-payment of taxes, that's a debt to the government, and the government can always levy on the property.
Yeah. In case it's the type of property nga, kunwari, agricultural land na hindi naman kasama sa mga pwedeng marehistro nga na lupa, then your grandparents really cannot acquire ownership of that land. In which case, the government can claim it back, diba?
Yeah.
We have plenty more to talk about. We would like to thank our guest, Attorney Sarte, for joining us tonight. Thank you.
You're welcome.
Thank
Thank
you
you
very
also for inviting me.
Thank you.
And let's take another short break. Legal Help Desk will be back.
One of the most common problems associated with inheritance is the inclusion and the division of assets with the testator's illegitimate children. The division of assets depends on a case-to-case basis, but one thing is clear. As stated by Article 991 of Republic Act No. 386, legitimate and illegitimate children shall divide the inheritance among them, taking one half of the estate, whatever the number of the ascendants or of the illegitimate children. The computation will always be as follows. The ascendants or legitimate children will get 50% of the deceased's assets, the surviving spouse will get 25%, and the illegitimate children will also get 25%.
You're still watching Legal Help Desk on the Solar News channel.
And we still have a few more questions from our viewers. Let's start with Joseph. He asks, we have an elderly uncle who has no ascendants. His wife died in 2000 and they have no children. To whom will his properties go when he passes on? Ayan. So Karen, what's your take on that?
Well, if he has no ascendants, then it should go to his brothers and sisters,
Yes,
diba? Kung may surviving.
Right.
So Joseph, check first. If your uncle has surviving siblings, kunwari meron ka pang mga ibang aunt or uncle, they will inherit. When you mentioned na uncle mo siya, if your parent na kapatid siya has already passed away, then you can inherit also from your uncle. Pagka meron ka pang parents, then it's your parent na kapatid niya who will inherit along with his other siblings na kapatid ng uncle mo. If not, then yung magmamana na yung mga nephews and nieces pagkapatay na lahat ng
Right.
kapatid ng uncle mo.
Yeah.
Our final question is from Fred, and he asks us, I have a son who is an addict and a constant gambler. My wife and I have done everything we could to help him get rid of his bad habits, but failed. I want to disinherit my son. Can I do so given his history? So we
Ayan.
have
Oh, someone here wants
gambler.
disinherit naman.
Oo.
Now, we have very strict rules. We have very strict rules when it comes to disinheritance. And unfortunately, having your son as a drug addict or even alcoholic is not sufficient grounds, no, for disinheritance. Medyo matindi yung pinaprovide ng
Yeah.
law when it comes to disinheritance.
Yeah,
no?
other examples
Yeah.
as grounds for inheritance would be attempt on the life of
Right.
the parent, for instance. So kung yung anak mo pinagtangkaan kang patayin, that's a ground for disinheritance. Or there's another more general ground, yung maltreatment. Kung minamaltrata kayo ng anak nyo, by word or by deed, so kung
So it's possible.
masamang salita, or pwede.
Yeah.
Pero hindi just because gambler siya or alcoholic siya. Kung dahil alcoholic siya ay lagi kayong, kunwari, sinasaktan kayo, then that's a ground for disinheriting.
Yeah.
Oo.
So again, just to summarize that, just purely being a drug addict is not enough. It has to be, you have to show that you're being maltreated, in which case that could be your grounds for disinheriting a person. But it has to be in writing na, hindi pwedeng I'm disinheriting has to be indicated and written down in the will.
So just to give a recap, if you're planning ahead, if you want to determine now who will get your properties after you pass away, it's not a very pleasant subject, but you can plan ahead by writing your own will. And under our law, there are very strict requirements when you're writing your will. One, you have to write it in the presence of at least three witnesses. And these three witnesses have to basically see you write your will and sign it in their presence. And you have to have it notarized as well.
Very strict yan.
Yes,
strict yung
very
mga
strict. Pag
requirements
meron
for
kayong
notarial will.
mali in any of these requirements, if you have any defects in the will or any shortcoming in these requirements, then they won't allow the basically execution of the will, meaning they will disregard the will.
Disregard it, yeah.
So be careful. It's better to consult a lawyer when you're drafting the will, just so you also know how much of your property you can give away.
And also, there's also the possibility, in case you don't want to do notarial wills, no, you can just do a holographic will. A holographic will it has to be handwritten by the testator, and all it requires is that it's dated and it's signed. And of course, it indicates there what you're planning with your property.
And lastly, of course, they cannot just decide to disinherit their kunwari, children or even any of your compulsory heirs. So you have to check the requirements in the law. Ano ba yung grounds for disinheriting?
Yeah. And that's all the time we have for tonight. I would like to thank our guests for joining us in clarifying some issues regarding the subject of inheritance and the like. We'd also like to thank you, our viewers, for the questions that you've shared to us. I'm Attorney Rod Nepomuceno.
And I am Attorney Karen Jimeno. Please like our Facebook page and add us on Twitter. Join us again next week for another round of discussion as we talk about your legal rights. Good night.